United States. Did Hillary Clinton receive treatment that was different than others?
She received no treatment different from any other. The only difference in this case is that we have, again, as I've indicated before, provided more information about, at least from the FBI's point of view, the investigative team's thoughts on this.
Perception, frankly, rooted in some realities of a dual-track or two-tiered justice system. And I know that you have dedicated your career to the pursuit of justice. I know you work for a blindfolded woman who's holding nothing but a set of scales. And I think it's important that she's blindfolded because she shouldn't see the race, the gender, the socioeconomic status, the fame or lack of fame of the person in front of her. And I'm sure you've experienced it like some of the rest of us. It's not just the suspect or the target or the defendant. The witnesses have to have confidence in the justice system. The jurors have to have confidence in the justice system. The public has to have confidence in the justice system. So this dual track, different set of rules for certain people than for others. It frankly should not matter whether you are running for president or running late to a kid's ball game. The same rules ought to apply to everyone. So let me ask you this. Why do you think it's important to use official email to conduct official business?
I believe it's important to do that. I think that certainly every department has chosen to craft the way in which they carry out their business, and it provides for a way of doing business in a secure system.
So you use official email to conduct official business?
Yes, sir, I do.
Okay. And do you ever email, send or receive classified information on personal email?
I do not.
I doubt you even use your USDOJ.gov account to send classified information, do you?
We have separate systems.
Right.
So there would be a separate
classified system
for that.
Right. So not only do you not use personal email to do it, you don't even use your USDOJ.gov. You have a separate dedicated system to handle classified information. Why?
We have a separate system to handle security needs.
But my question is why? Why is it important enough to you to not use personal email to conduct public business and to use a separate, more safely guarded system when you do handle classified information?
That is the practice that I've certainly always followed. It
But it's
allows
not
for the
just
protection.
it's not just a personal preference, is
No,
it?
it allows for the protection of the information, both on a regular, still sensitive, law enforcement types of matters, and then a classified system for separately classified information.
What element do you think was lacking in the statutes that you evaluated as it relates to Secretary Clinton?
So let me, again, as I've indicated before, and I want to make it clear that, as I indicated before, while the reason why I will not be going into the analysis that was provided and the discussion that we had between myself and the team is because we protect our teams and that they have to be free to provide information and analysis in a confidential way without the fear or impact of there being a political influence on that.
I understand
and that is why
that.
I have not gone into that type of discussion. What I can tell you is that the team did evaluate the relevant statutes that were considered in this investigation. They looked at all of the facts and evidence, and as in every case, they applied them to that statute to determine whether the elements had been met.
But my specific question to you, Madam Attorney General, is what element of which offense did you find lacking from an evidentiary standpoint?
Well, I would say that in order to answer that, I would have to go into the entire level of analysis.
Don't you think public perception in a single track justice system is important enough that you could at least touch on what you thought was lacking?
Congressman, in this case, we have taken the unusual step of discussing it in ways that the department typically does not, in order to provide more clarity into this situation. And while I understand that it is frustrating to a number of people, civilians as well as members of this body alike, we have taken extraordinary steps to discuss this matter in ways that typically we do not,
Well, let me ask you
particularly when
this.
charges are not brought. And as I indicated before, just so it's clear, my reasons for not going into the substance of the information that I receive and review before I made my decision to accept the recommendation are that the teams that I work with, whether it's this case or any other, be free to provide confidential analysis, discussion, without the input of any
With all due
kind of
respect, Madam
political
Attorney General,
influence.
you can do all of what you just described and still tell the people what element. I mean, the elements of a criminal offense are public, so that's not, there's no secret there. And for you to go through the elements and say, as Director Comey did, he said there was no specific intent. I'm out of time, but I suspect you have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the department or personally?
No, just as a prosecutor. There's involuntary manslaughter, there's reckless homicide, there's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
Well, Congressman, as I've said, I think you've mentioned a number of state cases there. But as I've said, the reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone to their decisions, nor will I apply one in accepting their decisions. That's why we have taken the unusual steps of providing greater information, as frustrating as that has been for a number of people to have additional information. That's why I took the unusual step of clarifying my role in this investigation.
I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to, but right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did, or whether President Clinton could do exactly what Secretary Clinton did. And I think that lack of clarity is bad for the Republic, quite frankly. I would yield back.
Yes, no.
Attorney Lynch, thank you for your time today. In 1965, a member of the Senate Labor Committee complained to the chairman of the committee that the new junior senator from New York was getting preferential treatment, and the chairman responded, "I'm not treating Bobby Kennedy any different than I would any other future president." So if a member of your staff took classified information home, put it on their server, their laptop, nothing would happen to that person?
We would review the matter and come to the appropriate decision. We would look to see at all of the relevant ramifications and see what fit.
So, you know, the meeting on the tarmac with former President Clinton, that was a pretty fortuitous meeting for you, wasn't it?
I would not say that.
Well, it gave you a perfect alibi, because if you had recused yourself, as some have suggested at the outset of this investigation, because you're friends with the Clintons and maybe hope to be Attorney General in her administration, then you wouldn't have, then you could stand here and say, I defer to the FBI director. But you didn't recuse yourself, but now you're using the meeting on the tarmac to basically say, to avoid the appearance of impropriety, I can't answer your question. Isn't that basically what's happened here today?
Congressman, I would not say it was fortuitous for me or for anyone. It led me to take, again, another unusual step in this case.
But that's what's happened today. In fact, I knew you weren't going to answer our questions today, and I apologize for wasting so much time here, because it's really not been very productive. And I asked my staff to count the number of times today you would say, I can't answer that question, or refuse to give an appropriate response. It's happened 74 times so far. So really, it's either one of two things. Either you're saying that because you want to avoid the appearance of impropriety, in which case you should have recused yourself, or you're trying to protect Hillary Clinton. So my colleague, Mr. Smith, asked earlier if you had talked with Bill or Hillary about serving as Attorney General in Hillary's administration. Have you talked to any of their staff?
No, I haven't.
Why did you tell the FBI security detail not to have any cameras or phones when you met with President Clinton on the plane?
I didn't make any comments about cameras or phones or anything.
So no one directed the security detail not to take any pictures or anything like that?
I did not. I didn't make any comments about cameras or phones or anything.
So last week, Director Comey, I think when he was being questioned by Mr. Gowdy, said that Hillary Clinton didn't tell the truth when she said that she turned over all the emails, that all the emails had been reviewed by her lawyers, that nothing was classified, that she only had one device. And he was quite pointed in his comments that she wasn't telling the truth about all of those matters and other issues. Do you think she told the truth?
You know, I'm not privy to the reasoning on that. My understanding is that after that exchange, the committee was going to decide whether or not to make a referral. If that were the case, the matter would be reviewed and looked at, and it would be not appropriate to go into it until then.
But you didn't recuse yourself, so you're really using that meeting on the tarmac as a way to avoid answering your questions. Isn't that what's happening here? You're saying it to avoid the appearance of impropriety.
I have talked about my conversation with former President Clinton as a way to explain how it would have no impact on the case. And I felt it was important to explain that because I had earlier decided that I would be accepting the team's recommendation, but that also we didn't talk about anything involving cases or the investigation itself. The conversation was, as I've noted earlier, primarily personal and on his part. We've taken that unusual step so that there would not be a view that there would be any influence on that, on this matter at all.
And you've used that to not answer our questions today.
I've answered your questions. If you have more, I'm happy to hear them.
Let's segue to the 3 mortgage settlements for billions and millions of dollars where in excess of $500 million was basically put into a slush fund to be steered towards liberal community service groups. Any more information on whether the attorneys at DOJ that were involved in mandating money not be steered towards conservative groups? Are there any repercussions for that?
Congressman, with respect to the issue of the settlements that were crafted in some of the residential mortgage-backed securities resolutions, I believe that our staffs have had discussions about that. We have provided information to answer questions about that. I believe we're working to provide more information. Again, let us know if there are additional questions there. Those settlements were, in fact, under the FIREA statute, did generate large fines that went to the U.S. Treasury. And payments to other groups were not of government funds, but they went to organizations that have helped literally tens of thousands of Americans modify mortgages and bring their homes out from being underwater.
Sure. And
allow them to keep their homes, which is the consumer relief that we were hoping we could effectuate through these settlements.
And the settlement probably violated the Miscellaneous Receipts Act, but that's a discussion for another time. Thank you, General. I yield back my time.
I don't know, or I can't answer, or in some cases, some combination of that. That's pretty much how you answer here is affirmatively yes, affirmatively no, or these shades of gray in between, correct?
Congressman, I'm not going to go into the internal discussions.
No, I'm not asking for the internal, but the character of questions.
My responses in that way.
So, so far today, you have rarely said absolutely yes or absolutely no, correct? You've mostly talked in terms of I can't answer that, or it's not appropriate, or see the FBI director. And so in light of that, and this is really a question of what do I tell the Marines, the sailors, Army personnel in my district, the veterans, the contractors, all those who work for the government with classified information. The former Secretary of State, in an unambiguous way, said repeatedly, both under oath and to the public, time and time again, I did not send or receive any information marked classified. And you're aware of that she had definitively said this repeatedly, right?
I believe her statements are on the record, and I defer you to that.
And I have referred to that. She unambiguously said something which was not true, according to the FBI director. So when you send and receive documents that are marked classified clearly, and according to her statement, 300 people have seen her email. Some portion of those people saw the ones that said secret, top secret, confidential, whatever. None of them are charged. What do I say to the tens of thousands of people that live and work in my district, that work for the federal government, including more than 47,000 Marines? What do I say when, in fact, saying something that isn't true, handling classified information in an extremely careless way, has no criminal ramifications? What do I say to them? How do I reconcile the fact that they know that their friends and colleagues have been prosecuted or fired for doing less in the past?
Congressman, I can't speak to any cases you may be referring to involving friends or colleagues. Again, I would refer you to the description that
I appreciate
provided
that,
about
Madam General, but I've got to ask you a question.
That follow this similar fact pattern. That is what I think we focus on.
Okay, let me go through.
Every case is different.
Every case is different.
Has to be handled in the same way. Every individual, whether they are former secretary,
so there will be some cases
has to be reviewed.
Madam General, I have very limited
facts
time.
And the law there.
General Lynch, you keep mentioning this professional team of career professionals. Were there any political appointees on that team? Any people who, in fact, did not work for the State Department or did not work for the U.S. Attorney's Office prior to President Obama coming into office?
Well, again, with respect to the team, typically we don't go into the composition of it. It was led by our National Security Division, and everyone on the team was a career individual.
Again, I'll ask the question with specificity. I'm not asking for names. Was there at least one person who was politically appointed that was on that team?
The investigative team was composed of career prosecutors and seasoned agents.
The question is, was there at least one that did not work a career, that was in fact an appointee, either confirmed or unconfirmed?
Congressman, I've replied to you as to the composition of the team, that all of them.
So your answer is no. There were no political appointees.
All of them were career lawyers as well as seasoned investigators.
Okay. I'll take that as a no, because that's the only way I can interpret what you keep repeating. So, last but not least, the American people are told that these documents were not a crime to carelessly deal with. Should I find a way to make sure that those thousands of documents are made public so the American people can evaluate just how insignificant they are, or how President Obama said there's classified and then there's classified? Are these documents that could be easily made available to the public, or are they too sensitive to be made to the public today?
Congressman, you may take the appropriate steps in terms of reviewing anything, and you may make requests for that, and we'll work to accommodate you with respect to that. I don't have an answer for you beyond that.
So you couldn't today. You could not characterize whether any or all of those documents would have to be retained privately because they're too sensitive to be made public.
The time of the gentleman has expired. The witness will be permitted to answer the question.
Thank you, Mr. Chairman. With respect to the handling of any of the documents or emails in this matter, because they involve another agency, we would have to work with the other agency. We always work with the agency that is termed the owner of information. So on behalf of the Department of Justice, I would not be able to give you an answer at this time as to those documents, because it would involve other agencies.
Thank you, Mr. Chairman. I yield back.
There were other things that contributed to that. One significant item I know the committee's been briefed on. There's been some public accounts of it which are nonsense, but I understand the committee's been briefed on the classified facts. Probably the only other consideration that I guess I can talk about in open setting is that at one point the Attorney General had directed me not to call it an investigation, but instead to call it a matter, which confused me and concerned me.